I'm criminal defense attorney Joseph Abrams. Today's video is the second in a three-part series in which I discuss the most important aspects of federal sentencing advocacy, or in other words, how to argue for a mitigated or lesser sentence. Last week, in part 1, I discussed the credibility of the defense attorney as one of several important aspects of sentencing advocacy. Today, in part 2, I discussed the defendant's remorse and acceptance of responsibility for the offense as another important aspect. Next week, in the final installment, I will discuss psychological evaluation reports and character letters as other important aspects. So, what does remorse and acceptance of responsibility look like? To begin with, judges want to see that the defendant has thought about what they have done and why they did it. Judges also want to know that the defendant has learned from the experience and that they are unlikely to reoffend. So, how can a defendant demonstrate remorse and acceptance of responsibility to the judge? To begin with, the defendant's statement to the court, also known as allocution, can play a powerful and significant role in this effort, and in some cases be a real game changer. However, an insincere or attorney-scripted statement by the defendant can have the opposite effect. Also, importantly, a defendant who exercises their right to allocution and makes a statement before the court should be prepared to engage with the judge, who often will question the defendant to learn more about them, why they committed the offense, and their future plans and goals. To be sure, the defense attorney has an important role to play in preparing the defendant for sentencing, for humanizing the defendant before the court, and for helping the defendant tell a compelling story. Other things to consider include telling the judge about the positive things that the defendant has done since their arrest, such as rehabilitation efforts, performance of community service, or efforts to pay restitution to victims. Another important issue to bring to life for the court is the financial and emotional support that the defendant provides to their family or other persons. However, and perhaps contrary to conventional wisdom, it is usually not a good idea to bring young children to court. Rightly or wrongly, it is often viewed as an emotional ploy by the defense. This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. I hope this was helpful. We'll see you next time in the final installment of the series when I discuss psychological evaluation reports and character letters as other important aspects of arguing for a mitigated sentence in federal criminal cases.